The United States Supreme Court is standing idly by as America's constitutional order is being ravaged by domestic enemies, ignoring the plain language of the Constitution and its brazen degradation by rogue government personnel. The Supreme Court shrugs its shoulders and wrings its hands as the Article II executive branch of the federal government, elected by the American people to carry out their political will, is made subordinate to scores of unelected, black-robed, tyrannical federal judges. One prominent example of the Supreme Court's reckless idleness is the case of former White House Special Counsel Hampton Dellinger of the Country Club Dellingers. This week, the Trump White House sent the Supreme Court an absolutely scathing letter over this Hampton Dellinger lawlessness, calling the Supreme Court out for their failure to faithfully and impartially discharge and perform all the duties incumbent upon the justices under the Constitution and laws of the United States. Let's talk about it. I am, of course, Attorney Andrew Branca for Law of Self-Defense, and if you like our content, and I expect that's why you're here, it would help us a great deal if you could hit that thumbs up like button and that subscribe button. That's what tells the YouTube algorithm to share our content more broadly, and of course, that's what we're trying to do, is grow the law of self-defense community. Our Constitution unequivocally places the entirety of the executive power of the federal government into the hands of a single elected president. Article 2, Section 1 of the Constitution states explicitly that the executive power shall be invested in a president of the United States. Concentrating the power of an entire branch of government into the hands of a single president, elected nationally by the whole of the people, is unique within our constitutional order. The Article 1 legislative power, for example, is diffused across 545 congressmen and senators. The Article 3 judicial power is diffused across at least 9 justices, and more pragmatically across nearly 1,000 federal judges. But 100% of the executive power is bestowed to the single elected president, currently our President Donald Trump. That elected president then delegates a portion of his executive power to his subordinates to carry out the political will of the people who elected him. It should go without saying that no subordinate can possess any executive power without that power having first been delegated by the president. This necessarily requires the consent of the president before any subordinate can have any claim to any executive power at all. The necessary ability to provide and deny such consent is a core and plenary power of the president under our constitutional order. The unavoidable consequence of this is that the president must be free to choose who possesses any delegated fraction of the executive authority the Constitution bestows solely in his hands. And that means the president, and only the president, has the constitutional authority to choose to whom he delegates his executive power, and also, by extension, the authority to choose whom to deny a delegation of his executive power. All of this was utterly uncontroversial American constitutional law until President Trump was sworn in as the 47th president of the United States on January 20th of this year, at which point scores of unelected, black-robed, tyrannical, inferior court federal judges have taken it upon themselves to order about the Article II executive branch president, elected by the whole of the American people to carry out their political will, as if he were one of their court clerks. The particular example I'd like to focus on today involves one Hampton Dellinger, formerly the White House Special Counsel, and now illegitimately claiming to retain that office. The White House Special Counsel is an executive branch position within the White House. It's kind of a whistleblower protection office, created in the aftermath of Watergate in the 1970s, and also an office that investigates and prosecutes two deeply executive branch functions, any employment disputes within the executive branch. The position was created by Congress, which orders that that position, once nominated by the president and confirmed by the Senate, is to be held for a period of 5 years and can only be terminated for cause. It's important to note here the arrogance of Congress in ordering the executive branch how to conduct its internal affairs, an arrogance that is most certainly unconstitutional. I've already mentioned in passing the 3 branches of government, the legislative, the executive, and the judicial. The founders separated government power into these three branches, the separation of powers doctrine, specifically to diffuse power and prevent its concentration into tyranny. The founders had, after all, just fought a desperate war against a tyrannical power to achieve their liberty and found this nation. And the Constitution they wrote to structure that new nation's governmental order was keen to prevent tyranny from ever again gaining a foothold. That's how vital the separation of powers doctrine is. It literally serves to preserve liberty and frustrate tyranny. An inherent quality of the separation of powers is that the various branches of government are utterly prohibited from infringing on the core and plenary powers of the other branches, except as explicitly permitted by the Constitution itself. And such exceptions do exist, commonly referred to as our Constitution's checks and balances. For example, the superior officers of the executive branch require the advice and consent of the Senate in the legislative branch. The judges of the judicial branch are subject to impeachment by the legislative branch. The executive branch can veto legislation passed by the legislative branch. But these infringements are ones specifically called for and permitted by the Constitution. Except for these, infringements by one branch on the core and plenary power of the others is utterly forbidden. For example, one core and plenary power of the president is the power to issue pardons. If the president issues a pardon, there's absolutely nothing that either the legislative branch or the judicial branch can do to thwart that pardon. And for all of United States history until this very month, the ability to fire principal executive officers of the executive branch was universally recognized as a core and plenary power of the president that he could exercise at his will. After all executive power flows from the president. And if the president declines to grant a delegation of power to some person, that person has no independent claim to any executive power at all. Until this very month of February 2025, when fired Executive Officer Special Counsel Hampton Dellinger claimed the authority to possess executive power independent of that granted to him by the President Trump who had fired him. Recall that Congress had called for the special counsel, an executive branch position, to be held for a 5-year term and to be terminable only for cause. It should be obvious that under the separation of powers doctrine, Congress is utterly without constitutional authority to order the executive branch how to carry out its internal affairs, any more than the president has the authority to tell Congress how to conduct its own internal affairs, when to have committee meetings, on what bills, and how to vote on those bills. It's also notable that Hampton Dellinger had been nominated to the special counsel position in 2024 by the previous administration of President Biden. Probably not by Biden himself. It seems unlikely that Biden was mentally competent at the time, but by whoever was manipulating the hollowed-out husk we were calling President Biden. Having taken the special counsel position in 2024, given the unconstitutional 5-year term arrogantly mandated by Congress, Dellinger would have retained his executive office for the entirety of President Trump's second term, despite Trump not wanting Dellinger to possess any of the executive authority that only Trump, as the newly elected president, could delegate. Not wishing to delegate any executive power to Dellinger, on Friday, February 7th, Trump fired him without stating any particular cause for termination, simply at the president's discretion, as American law had always recognized was the president's explicit prerogative. On Monday, February 10th, Dellinger launched a wrongful termination suit, claiming he'd been fired in violation of the unconstitutional congressional condition that he could be terminated only for cause. Now, there's nothing too remarkable about all this so far. Other principal officers had sued for wrongful termination in the past, and if they were successful in their suit, they were rewarded with monetary compensation in the form of back pay to make them financially whole. But that wasn't good enough for Dellinger. He wanted more than money. He wanted power. He wanted executive power, including the power to order that other executive branch personnel not be fired, even if the president himself wants them fired. Dellinger sought out an unelected inferior trial court federal judge to order President Trump to reinstall him in his office. and allow him to continue exercising the executive authority that Trump had declined to delegate to him. In other words, Dellinger demanded that he have the personal authority to exercise executive power outside of the discretion of the president to whom the Constitution delegated the entirety of the federal government's executive power. Dellinger also asked that Trump be prohibited from firing him even for cause, which even Congress had permitted. And federal trial judge Amy Berman Jackson, appointed to the bench by Barack Obama in 2011, was happy to oblige. Judge Jackson issued a temporary restraining order that did everything Dellinger asked for. This TRO, incidentally, effectively made Dellinger an executive branch principal officer who was not answerable to anyone. The only person who would have had the authority to fire Dellinger under any circumstances was President Trump. And now the Jackson court had forbidden Trump to do that. Dellinger was now free to act as an executive branch principal officer and issue orders that directly contradicted those of the president, and there was literally nobody who could stop him. Jackson's issuance of a TRO against a core and plenary power of the executive branch was also a grievous infringement of the separation of powers doctrine and immediately caused irreparable harm to the dignity of the executive branch and our very constitutional order. After all, if any one of the many hundreds of unelected inferior federal trial court judges can simply order about the Article 2 executive branch elected president as they wish, what core and plenary power does the executive branch even have? How is the executive branch to be held accountable to the political will of the whole of the people that elected the president? Why bother electing a president in the first place if there's simply to be a rubber stamp of hundreds of unelected tyrannical judges? Now, in normal litigation between normal parties, a temporary restraining order of this type is considered unappealable to a higher court, largely because they're intended to be so transitory, lasting only for 2 weeks. The purpose of the TRO is simply to maintain the status quo, while a few days can be taken to prepare reasoned argument for a more durable preliminary injunction. Imagine, for example, a scenario in which you wake up to find men with chainsaws about to cut down a tree you own in your yard. You don't have a couple of weeks to prepare a preliminary injunction because by then the tree will have been cut down. So you rapidly secure a temporary restraining order. That TRO is not appealable by whoever wants to cut down the tree, but it only lasts a couple of weeks until you can both argue around the issue of a longer preliminary injunction. If you manage to secure a preliminary injunction, which would normally last for the entirety of the lawsuit about the tree, then the tree cutting people are free to appeal that preliminary injunction to a higher court. Here, however, we're not dealing with normal litigation between normal parties. We're dealing with litigation in which the defendant and the party being restrained by the TRO is the Article 2 executive branch elected president. Any infringement on the core and plenary powers of the United States, any branch of the United States, for even an instant, ought properly be deemed to be causing irreparable harm and appropriate for immediate appeal to a higher court. Certainly that's how the law deals with any infringement, no matter how slight or transient, on an enumerated constitutional right of an individual, such as the First Amendment right to free speech, that's being arguably infringed by the government. The slightest infringement is considered to qualify as irreparable and immediate harm. Last week, the White House appealed Judge Jackson's unconstitutional TRO to her bosses on the Court of Appeals for the District of Columbia, asking them to vacate or remove the TRO. The Court of Appeals declined on the specious technical grounds that TROs are generally not appealable, and so they claim they lacked jurisdiction to consider the request. On Monday, February 17th, the White House then appealed directly to the U.S. Supreme Court in the person of Chief Justice John Roberts, who is the justice designated to hear such appeals from the District of Columbia Circuit. The White House asked the Supreme Court to vacate the Dellinger TRO on many of the grounds I've just explained here. On Friday, the end of the week, February 21st, the Supreme Court issued a response agreeing to do absolutely nothing. Written by Justice Roberts, the decision of the court was to hold the request to remove the TRO in abeyance, meaning to just wait and do nothing, on the grounds that the TRO was set to expire in just a few days anyway, on Wednesday, February 26th. The court essentially decided to wait out the expiry of the TRO so they wouldn't have to make any hard decisions. Well, Hampton Dellinger saw this for the weakness that it was and took immediate advantage. The following Tuesday, a day before the TRO was set to expire, Dellinger issued executive orders overriding President Trump's own orders that 6 executive branch probationary employees be fired. In effect, then, the risk of Dellinger issuing executive orders that were contradictory to those of the Article II executive branch elected president was no longer simply hypothetical. Dellinger was now actually doing it. Even worse, Dillinger's orders countermanding those of the president were then affirmed by yet another executive branch agency, the Merit Systems Protection Board, whose own chairman was yet another executive branch officer who had been fired by President Trump and who an unelected inferior trial court judge had reinstalled in her position over Trump's orders. The next day, Wednesday, February 26th, Judge Jackson had the parties meet in her court to discuss the TRO that was scheduled to expire that day, and instead, Judge Jackson extended the TRO for another 3 days until Saturday, March 1st. So that's another 3 days in which the Article II executive branch authority of the elected president is being allowed to be subordinated to the purported executive authority of the unelected special counsel Hampton Dellinger. In response to that extension by Jackson, on the same day, Wednesday, February 26th, the White House sent a scathing letter to the Supreme Court itself, chastising them for allowing this degradation of our constitutional order to continue for even a moment longer. The letter is addressed to the Honorable Scott S. Harris, clerk of the Supreme Court of the United States. It was sent by the Solicitor General, Sarah Harris. I don't believe there's any relation. The Solicitor General is essentially the White House lawyer. The letter reads, "Dear Mr. Harris, on February 16th, 2025, the White House filed an application to vacate Judge Jackson's temporary restraining order reinstating Hampton Dellinger as special counsel after the president had fired him. On February 21st, this Supreme Court issued an order holding the application to vacate the TRO in abeyance until February 26th, today, when the TRO was set to expire. Today, after a hearing on Hampton Dellinger's motion for a preliminary injunction and cross motions for summary judgment, Judge Jackson extended its TRO until Saturday, March 1st, so that it could give close consideration to all the pleadings submitted by the parties and complete a written opinion. In the meantime, the harms to the executive branch from the trial court's TRO have become even more concrete. The same day that this court held the government's application in abeyance, Hampton Dellinger filed administrative actions before the Merit Systems Protection Board challenging executive agencies' firings of 6 probationary employees. Hampton Dellinger sought an immediate 45-day stay of those firings while my agency continues to investigate further, and announced that he is considering ways to seek relief for a broader group of employees. Although Hampton Dellinger had told this court that he is an inferior officer subject to the MSPB's supervision, he told the MSPB that the board must grant the special counsel's request for a stay unless the special counsel's claim is inherently unreasonable. An MSPB member promptly granted the requested stay, agreeing that deference is given to the special counsel's initial determination and that a stay will be denied only when the stay request is inherently unreasonable. Hampton Dellinger then publicly announced, "These stays represent a small sample of all the probationary employees who have been fired recently, so our work, his work, is far from done. Agency leaders should know that the Office of Special Counsel will continue to pursue allegations of unlawful personnel actions, which can include asking MSPB for relief for a broader group of fired probationary employees." In short, a fired special counsel is wielding executive power over the elected executive's objection to halt employment decisions made by other executive agencies. The MSPB, the entity that Hampton Dellinger argues is responsible for supervising him, is deferring to his stay requests so long as the requests are rational. The MSPB, moreover, is being led by a chairman who has herself been fired by the president only to be reinstated by a federal trial court. These developments underscore the grounds for vacating the trial court's order. The government respectfully asks that this court, at a minimum, continue to hold the application in abeyance if the court does not grant it now that the TRO has been extended. Once the trial court issues its final decision, presumably on March 1st, it may become necessary for the government to request further relief, at which point the court could dispose of the present application along with any subsequent application. I would appreciate it if you would circulate this letter to the members of the Supreme Court. Sincerely, Sarah M. Harris, Acting Solicitor General. Folks, every second that the Supreme Court allows this federal court to infringe on the core and plenary powers of the Article II executive branch elected president, the Supreme Court is allowing the continued degradation and collapse of our constitutional order. And that's true for all of the many scores of such interventions by the unelected inferior trial court judges who are aggressively infringing on the core and plenary powers of the president for the apparent political purpose of foiling the political will of the American people who elected President Trump. These activist judges should, of course, be fired for cause, for having failed to meet their Article III, Section 1 employment conditions for federal judges of serving under good behavior and removed from the bench. But that's a topic I've addressed at length in a different video that I'll link in the description. And shame on SCOTUS. Every one of those justices took an oath to faithfully and impartially discharge and perform all the duties incumbent upon them under the Constitution and laws of the United States, and they are utterly failing to adhere to that oath. On Saturday, March 1st, Judge Jackson's TRO finally expires, supposedly. It's my expectation that she will then issue a preliminary injunction, a durable order, that Hampton Dellinger be retained in his special counsel position throughout the duration of his wrongful termination suit, exercising executive power not delegated to him by President Trump for what could be months or even years. I suppose then we'll see whether the Supreme Court is finally going to step up to the plate and do its damn job and defend the U.S. Constitution from these illegitimately overreaching, unelected, inferior court tyrannical federal judges. All right, folks, if you like our content, then I'd just like to ask you to hit the like and subscribe button, ring that bell, as it really helps us out, and it's free.